All right, the meeting of the Rent Control Board is hereby called back into to order after its closed session. And please, everyone, join us in the salute to our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, if anyone wishes to address the board, either on a specific item on tonight's agenda or at public comments, and you haven't already, please see the secretary to fill out a speaker slip. And next up, can we have a report on tonight's closed session from our general counsel?
Thank you, Chair. The board convened in closed session at 6:08 p.m. and adjourned at 6:45 p.m. with no reportable action taken. Thank you.
Thank you. Moving on to agenda item 5. If commissioners have had an opportunity to review the minutes from our June 12th meeting, may I have a motion for their approval? Commissioner Leslie?
I move that we approve the minutes.
Second. Well, we'll go with a motion by Commissioner Leslie and seconded by Commissioner Ambrose. May we have a roll call vote, please?
Yes. Commissioner Ambrose?
Yes.
Commissioner Dudek?
Yes.
Commissioner Leslie?
Yes.
Vice Chair Ivanov?
Yes.
Chair Gonska?
Yes.
Motion carries.
All right, moving on to item 6. Does the executive director have anything to report to the board?
Thank you, Chair. Good evening to you, Vice Chair, Commissioners. Before I make my announcements, I'm very pleased to welcome our new city manager, Oliver Chi, who has graciously joined us this evening to introduce himself to the board.
Is that working? Or hello.
It's on now.
Hello, good evening. My name is Oliver. I've had a chance to meet a couple of you here on the Rent Control Board. Chair Gonska, members of the board, thank you for giving me just a few minutes to say hello. I've been with the city now for about 4 weeks. I've had a great time getting to know Jonathan, trying to learn all the different operations here in the city. I just am trying to make it a point to visit with all of our boards and commissions. I recognize how much time and commitment it takes to serve on a board, so thank you for what you do on behalf of Santa Monica. I'm just, gosh, I'm so excited. We're in Santa Monica right now. Like, how cool is that? Just really looking forward to working together with the Rent Control Board, with Jonathan and his team, as we try to continue to make Santa Monica the best version of itself possible. Thank you for the opportunity again, just to say hello, and again, thank you for what you do for the city.
Thank you for being here tonight. I haven't had a chance to meet you personally yet, but this is everything I've heard has been nothing but great things, and I'm excited about your enthusiasm for the role here. And so, thank you for coming here tonight. I think we really appreciate always when we have, whether it's the city's attorney's office or other city staff or department heads coming to report throughout the year on various things that come before us. So we're an independent agency, but obviously there's a lot of collaboration with other departments in the city. So having that good working relationship is really important. So thanks for being here tonight.
Oh, absolutely, and thank you again. Have a great evening.
Since our last meeting, the agency has staffed tables at Pride, the State of the City event, and National Night Out. Our Public Information Department is planning to engage the community at additional events, and I will update the board and the public as those plans take shape. Registration fee invoices were sent following your last meeting, with payment due in full by August 1st. Second invoices reflecting a 4% late penalty were sent out this week. Payment must be received no later than September 7th to avoid additional penalties. If a landlord has not yet paid their registration fees, they may not pass through 50% of the per unit cost to each tenant. In addition, the general adjustment may not be applied until the total balance is paid in full. As a reminder, payments can be made online through a Civics account or via one-time payment at rentcontrol.santamonica.gov. Tenants or landlords with questions about these mailings are encouraged to contact us at 310-458-8751 or email rentcontrol@santamonica.gov. That concludes my comments. Thank you.
Thank you very much. Now we'll move on to public comment. This is the time set aside for members of the public to address the board on matters that are not included on the agenda tonight. So please limit your comments to those topics that are not on the agenda, but that are within the board's subject matter jurisdiction. And just please remember that we cannot take any official action at tonight's meeting on anything that's not on the agenda. But I do have one speaker slip so far. Stephen Kowalczyk, if you want to step up to the mic and to the podium here. And you'll have 5 minutes to address the board whenever you're ready.
I appreciate that very much. I have 2 packets, so I'm going to just hand this out for. Please not be part of my time. This is part 1. In this, you'll have a copy of my speech. I'm from South Side of Chicago, so my dialect.
I'm from there as well.
Years.
We're both from
pretty
Chicago.
rough, so I just want to make sure everybody receives a copy.
Thank you.
I'm going to send up another round. I didn't know if I was going to get the 5 minutes, so I broke this down to 2. And I'm going to be, it looks like, one short for Mr. Moore. Oh, no, where's that? You did get a copy. Because I got the 5 minutes, this will be part 2.
Thank you.
In the front, you're going to see a copy of what I'm going to be discussing. And then I have backup documentation with regards to everything that's within the speech. I handed out all my copies, so I got to get to everything else. Good evening, the members of the Santa Monica Rent Control Board. My name is Stephen Kowalczyk, and I serve as the offsite property manager for Colonial Manor Apartments, a family-owned and operated community since 1959. The property is currently owned by Ms. Barry Sirocco, a 78-year-old widow who remains deeply committed to maintaining affordable housing in Santa Monica. First, I want to thank this board for the opportunity to speak and share important information regarding Colonial Manor and our ongoing efforts to comply with and support the Santa Monica Rent Control Division. Colonial Manor consists of 26 units, 10 two-bedroom units, 16 one-bedroom apartments located at 2711 Kansas Avenue on the corner of Kansas Avenue and Stewart Street. The building was constructed in 1949 and has long served as a home for low-income families. Here's the breakdown of rental structure. 1 HUD-subsidized unit, 2 units rented at $2,500, 1 unit at $1,800, 8 units ranging from $1,064 to $1,278, 3 units at $754, $840, $668 respectively. This is monthly rents. We're currently undergoing a comprehensive renovation, including new roofing, window replacements, full exterior painting, and planned interior upgrades. Mr. Sirocco is investing over $1.5 billion of her own money into these improvements, not only for future tenants, but also for the company and safety of our current residents. Despite this commitment, we face significant challenges due to Santa Monica's rent control regulations and the actions of the city attorney's office. Many of our long-term tenants do not have written rental agreements. As a property manager, I have attempted to formalize these verbal agreements and maintaining the same rental terms as a month-to-month status, not to disrupt tenancy, but to ensure we can retain our insurance coverage. Given the increasing difficulty of securing property insurance in California, especially after events like the Palisade fires, written leases are essential, and without them, our current insurer may withdraw coverage, and obtain new insurance could be nearly impossible, jeopardizing the future of Colonial Manor. Unfortunately, my efforts to secure written leases were met with resistance by the city attorney, Jonathan Frank, instructed me to cease these efforts, despite my repeated explanations that this was a necessary step to protect both the property and the tenants. Shortly thereafter, a letter was sent to all tenants, effectively halting all communications and preventing any dialogue about the insurance issue. I attempted to hold a town hall meeting to explain the situation, but tenants declined to participate, citing the attorney's letter that was sent out. I further warned that discussing insurance matters with the tenants could be construed as harassment, subject to heavy fines. This approach has left me with no clear path forward. I've been told what I cannot do, but nobody has offered guidance on what I can do to resolve this issue. In my view, the city attorney's actions, particularly the unilateral communication with the tenants, have created an atmosphere of fear, confusion that undermines collaboration and transparency. Imagine the consequences of losing insurance coverage. A single slip and fall incident could result in devastating liability for both the property owner and the tenants. Today, I respectfully ask this board to review the situation and provide guidance. We want to remain compliant with the rent control laws and continuing offered affordable housing to Santa Monica residents. We're not seeking to displace tenants or raise rents. We're seeking sustainability. Colonial Manor's ownership and management fully support the mission of the Santa Monica Rent Control Division. We believe in working together to create a win-win-win situation. A win for the tenants that need affordable housing. A win for the Rent Control Division in fulfilling its mission. And a win for Colonial Manor, remaining a viable part of the rental community. I would welcome some opportunity to meet each one of you individually with the board members to explore solutions and foster a spirit of cooperation. As I often say, it's better work with an open hand than a closed fist. The second part I'm here also to urge you to review what I believe is an unjust action taken by the city attorney's office.
Sorry, just excuse me. The time has expired, so I know you have a second part here. You gave us a lot of documentation, but if you can just summarize very quickly in just a few seconds the rest of your comments tonight, and then we have to move on with our agenda.
Yeah, well, we have a lawsuit. I have the speech. Please read part 2. I'd definitely like to talk to everybody individually, especially our new elected city commissioner. I think what has happened has been completely unjust with regards to the way the city of Santa Monica's attorneys have taken a position without fully investigating. I have in this packet 2 letters from UCLA Medical that supports my claim. I also have a marriage certificate to somebody who is being apparently mentally Alzheimer's, and this is with one of the tenants that the city attorneys are currently coming after.
I apologize. We do have to move on because we have to stay to the time limit.
I understand.
But thank you for the information.
I would appreciate the opportunity, though. You have my contact information, and I'd like to set up a separate meeting with each one of you. I think this is important because
thank you.
You guys manage this.
I think your time has ended, and we have to stay consistent with everyone who has the same time.
I appreciate that.
Thank you.
Thank you very much.
Chair.
Judy.
Who signed up for? He also would like to speak on this item.
Okay, gotcha. Okay. We have another speaker during public comment, Michael Soloff. You can step to the podium, and you'll have up to 5 minutes to address the board when you're ready to begin.
Thank you.
There you go. Try now.
Thank you. This will be very short. I'm here tonight to speak on a later item in my personal capacity, but by coincidence, I happen to be the lawyer representing the tenant that's being described in the second part of the prior speaker's comment, and I would just make myself available to each of you as well to explain our perspective on that matter. Thank you.
Thank you. All right, we're moving on to agenda item 10, jurisdictional items. We have 2 appeals tonight. The first one is a decrease petition at 1143 Harvard Street. and it's an appeal of the decrease. May we have a staff report, please?
Good evening, Commissioners. The tenant of Sierra Jones, the tenant of Unit B at 1143 Harvard Street, filed a rent decrease petition alleging maintenance conditions and reductions of housing services. Most of her rent is paid through housing assistance vouchers. Her portion of the rent, which is the portion that is subject to the rent decrease petition, is $277. The hearing officer granted decreases totaling $15, reducing her MAR to $262. Ms. Jones has appealed the decision. She argues that she should have received a decrease for conditions for which she was denied a decrease and a higher decrease for those which she received one. She also complains that she was not given an opportunity to submit additional video evidence, and she also complains about conduct by the landlord that she characterizes as harassment. The board reviews this matter as an appellate body, therefore it should affirm the decision if its findings are supported by substantial evidence and reasonably supported by the record. As detailed in the staff report, the record reasonably supports the hearing officer's denial of a rent decrease for alleged cracks that remained after the owner repainted the wall and bedroom ceiling, which were not corroborated by further evidence. The record also reasonably supports the denial of a rent decrease for the alleged damage to the kitchen door, given the hearing investigator's report and Ms. Jones' failure to submit evidence to prove her allegation. And the record reasonably supports the denial of a rent decrease for minor gaps between the molding and the wall that appeared to be the result of normal wear and tear. The hearing officer's award of $5 for the moderate to small holes in the exterior stucco wall of the unit, without any evidence that the holes were more than a cosmetic defect, is supported by substantial evidence and reflects the tenant's very low rent in accordance with the board's regulations. The award of $5 for a porch light that gives a buzzing sound but that otherwise functions is also supported by substantial evidence and reflects the tenant's rent. And the award of $5 for a window that Ms. Jones said was still slightly difficult to open after it was repaired and which only pertained to one window in the unit is also supported by substantial evidence and reflects the tenant's rent. The record also doesn't support Ms. Jones' claim that she was denied an opportunity to submit additional evidence or that she even requested the opportunity to do so. And neither the board's regulations nor case law give the board the authority to award a rent decrease based on harassment conduct, which is something that the city attorney's office investigates. Because this decision is supported by substantial evidence and is in accordance with the board's regulations, staff recommends that the board affirm the decision.
Thank you. And I don't believe we have representatives from the tenant or the landlord here tonight. So, oh, do we? Yeah, if you'd like to speak, what's the time limit on?
Awesome, it's fine.
Up to 5 minutes. Okay, yeah, you can approach the podium here.
My name is William Pokinghorn, and I
think it should be on now. You have up to 5
Here we
minutes.
are.
Yeah, you'll see a timer there in front of you, so you have up
My
to
name's
5 minutes.
William Pokinghorn. It hasn't started yet, but I'll start. I want to. I certainly do not oppose the award and nor the staff report that supports the award of the hearing officer. I've gone through two separate petitions for a rent decrease for this particular tenant, and I'll only say this: the process is time-consuming for the city, far less so for me, but it's remarkably thorough and it's remarkably fair. It begins with the petition itself, but I think the key document is something called an on-site inspection and photograph report by, and in my case, and in both of these cases, by one Daniela Wadnitsky, extremely thorough. Hearing officer Jenna Miyahara carefully reviews each of the items that's identified in the in the inspection report and produces a report of nearly 30 pages. The staff then reviews that report, and as the attorney mentions, found that the findings of the hearing officer are supported by substantial evidence. So I compliment the city for the process that it undertakes on behalf of a tenant who has brought 2 petitions for rent decrease in the 3 years that she's lived at this apartment. And in each case, the landlord, that would be me, has agreed to perform all the maintenance and repairs that were recommended on the for the apartment. Has spent a lot of money on this particular apartment. The first petition for rent increase resulted in a compliance determination by the hearing officer on a basis of a request by me, stating that the condition of the apartment was satisfactory with reference to the applicable ordinances and building standards, even though several small items of repair had not been completed. And that was because the hearing officer found that the tenant had refused to cooperate in allowing workers from the owner to come into her apartment to do the work that the hearing officer said ought to be done. And now on the petition for the second petition for a rent decrease, the one that's before you now, I have submitted a further request because after our hearing in front of a hearing officer, Miyahara, in October of 2024, almost a year ago, we spent 3 months trying to gain access to the tenant's apartment to do this work. 16 separate requests on behalf of a property manager asking her for a time and a date when we could come in and do the work. And the request for a compliance determination is not before you today. Only the appeal from the ruling itself, which I say I support. But so I'll end by just a further compliment to the city's efforts on this behalf. Thank you.
Thank you very much. Do any commissioners have questions about the staff report before we move to deliberation? What's that? Oh, okay. Commissioner or Vice Chair Ivanov.
Is the only reason that we're deviating from the rental ranges here because the MAR is substantially below market rate? Is that the only justification, or are there other factors at play there as well?
As well as the level of the impairment in totality, in proportion to the totality of services that are provided by the rent. So it's a combination of the level of the impairment as well as the very low rent.
Thank you.
Commissioner Leslie?
That was my concern as well, because I wanted to know whether or not the hearing officer took into account the entire rent instead of just the tenant's portion, because I see that it's mentioned several times within the report, and hopefully that the tenant didn't they received the same report here that we got.
Yes.
Because I think I would take issue with saying, well, the tenant only pays this amount, because it would kind of give the perception of being discriminatory as far as they only paid this amount. So it seemed as if the hearing officer kind of said, well, they only paid this, so this is okay within this, you know what I'm saying, the way that it was written. So that was a concern for me.
The portion that is subject to the rent decrease petition is the low rent,
but
it wasn't just that. It was also the level of the impairment was minor as detailed in the staff report.
Yeah, I understand the detail, but I'm saying that the number of times that it's repeated throughout the report, instead of just stating the facts and not mentioning the amount of rent that's being paid, seems kind of discriminatory in stating it over and over repeatedly throughout the report. And that would be a concern for me if I was the tenant. So I'm just putting myself in the tenant's shoes. So if that could not be done in the future, like you can, whoever's writing the report, like write it once, not 3 or 4 times throughout the report, because it kind of gives a kind of slight lead to discriminatory practices. Thank you.
Commissioner Ambrose?
If our public speaker wanted to come back, we're allowed to ask questions? Was that right?
Yeah, that'd be fine.
Oh. You mean me? Yes, you. Sorry, I didn't catch it. Well, so This issue is not before us, but I would like to ask if you would like to speak to, and you briefly, I think we're talking about the vendors coming to the unit, but that Ms. Jones has claimed harassment and between the owners.
I'm sorry, Commissioner Ambrose.
I can't ask.
No, we need to stick with the appeal before us.
Okay,
Yeah,
thank you.
Thank you.
Okay, thank you for coming up, but we can't discuss that right now.
That's all right.
That's
Thank
all right.
you.
Did you have any other questions about the report? Okay. I do have a couple of brief questions. It seemed like there was an issue there was a complaint that from the tenant that they weren't able to submit the videos that they wanted to submit or something like that. It seemed like from the staff report that it may have just been some sort of technical issue. She referred to like having to submit shorter videos. But can you elaborate in terms of like the importance of?
I reviewed the
full
hearing,
video?
and there was at no point did the tenant request, even when she submitted the video and referenced the video, did she ask for the opportunity to submit additional videos or ask the record to be kept open or any of the things. And there was no mention of it during the hearing.
So that only came as a complaint in the appeal.
In the appeal.
Gotcha. Okay. And I think there was also a part about Ms. Jones alleged that the cracks were not repaired when the walls and the ceiling were repainted, but she did not submit any evidence to corroborate her allegations. I just wanted to point out that that the tenants always have the ability to file a new decrease petition if, in that case, if she had evidence that wasn't submitted, but she wants to submit it with a new decrease petition, she could do that, right?
Right, in accordance with the regulations.
Okay, thank you. Commissioner Leslie?
So my question is that I know that this process can be kind of nerve-wracking for an everyday person or everyday citizen within our city. And I know that our staff helps people with this. So what I'm wondering, was she provided the answers to her questions, like how to submit her video? Did somebody provide her instruction? Because I did review the video. It's very short. It looked like somebody didn't know what they were doing, but there's also reference to the video in the report saying it looked like somebody poured water down out the window. I was kind of curious as to how they surmised that.
All parties are instructed by hearing staff as to how they can submit evidence. If there are any questions about how to do that, they're always provided assistance as well. That's what the hearing staff does.
Thank you.
Let me make one comment that I think might be helpful here.
Unfortunately, we can't take any further, but unless the commissioner had a question for you, but I think we're good.
Do you have anything to add to this?
Sorry, Commissioner Leslie, what was your?
No, I was asking him what was it? I wanted to ask him exactly what is it that he wanted to ask us or submit into this. Wait. Take that back.
I was going to suggest if you have a specific question, because otherwise you're leaving it open.
No, I'm sorry, sir. I can't. Thank you.
Thank you very much. Okay, does any commissioner wish to begin deliberation or make a motion? Vice Chair Ivanov?
I don't see any clear error here, so I would move to affirm the decision.
Do we have a second?
I second the motion.
Oh, do you have a question?
Well, I can second the motion and still have discussion.
I think you should ask first or say what you'd like.
Okay, so then I just have comments. First, I found the investigation by the hearings officers very thorough, and I want to thank our hearings officer for doing that. I also wanted to comment in respect to the 3 instances of the award amount being less than the ranges, and that finding being based off of proportionality to the rent, and as well as the actual noticeable damage that we are allowed to go outside of that range, and that's provided in our law, Section 4200C. allowing us to go either lower than or higher than the ranges that are set forth. So I agree with that finding. And with that, I think I'll just second the motion.
Okay, we have a motion from Vice Chair Ivanov, seconded by Commissioner Ambrose. May we have a roll call vote, please?
Yes. Commissioner Ambrose,
Yes.
Commissioner Dudek,
Yes.
Commissioner Leslie,
No.
Vice Chair Ivanov,
Yes.
Chair Gonska.
Yes.
The motion carries.
Okay, next up, we have 10A2, which is a decrease, an appeal of a decrease petition for 143 Hollister Avenue. And may we have a staff report, please?
Commissioners, Fiona Bowles, who's the tenant of Unit 17, filed a rent decrease petition alleging maintenance conditions and reductions of housing services. Her MAR was $2,025, and the hearing officer granted her decreases totaling $95. Ms. Bowles has appealed the decision, and she argues that she should have received a higher decrease for deficient blinds on one window in her apartment. The board, again, reviews this matter as an appellate body, therefore it should affirm it if the decision is findings are supported by substantial evidence and reasonably supported by the record. The range for deficient window coverings is $18 to $228. Here, the hearing officer granted a decrease of $20. The video evidence and the inspector's report shows that the blinds installed a couple years ago on one window do not open or close evenly, and they fan out on one side, and also the pull cord has detached from those blinds. Neither Ms. Bowles nor the hearings investigator provided evidence as to whether the blinds could still be closed manually. In granting the amount of the decrease, the hearing officer said that she selected $20 because that one blind could still be closed for privacy. But since there's no evidence as to whether, in fact, it can still be closed for privacy, substantial evidence doesn't support the hearing officer's basis for the amount of the decrease. And the absence of evidence on this point also does not support Ms. Bowles' argument that the decrease should be higher because they can't be closed for privacy. We just don't have the evidence. Staff therefore recommends that the board remand this matter to the hearing officer for this limited purpose, to evaluate the amount of the decrease based on such evidence and the totality of the record.
Okay, thank you. Do any commissioners have questions about the staff report? Commissioner Leslie?
This unit faces the street, right?
When I looked at the photos in the record, what it actually faces is a big empty lot, and then beyond that lot is the street. So I don't know if you can, to what extent you can see it from the street. It just wasn't available to me from the evidence that was in the record.
Okay, thank you.
Vice Chair Ivanov.
So here it seems that the hearing officer arrived at their decision in terms of the amount of the decrease based on a fact that is nowhere in the evidentiary record whatsoever. Which is the fact that whether the blinds can be closed or not for privacy. And so based on that, I would be inclined to move to remand this decision for the limited purpose of determining whether the blinds can be lowered for privacy, and then once that is determined, determine a new amount for the decrease.
Do we have a second? Commissioner Leslie?
I second that motion.
Before we move to a vote, I have just a question of, because I don't think we've actually done this before, at least when I've been on the board, to remand it back. So what does the timeline look like for that? Because I know just for a new hearing, there's a backlog. So what does the timeline look for reviewing something that's a relatively minor issue like this? And is there any way to expedite that? Like, where does it fall in the queue with all the other hearings that you have going on?
That will depend on the language of the remand. And so if you're remanding to do, fact-finding, then we will send Ms. Wodnicki back out. And however long that takes, then I would presume there would be an evidentiary hearing because I'm sure there's disputed sides. And then we would have to produce a written report or written decision. So I honestly can't give you an exact date because Ms. Wodnicki has a vacation scheduled later this month for a week and a half. We have other expedited matters on our schedule right now that we have to put ahead of other things. And so I would say at least 6 weeks.
Okay. And is there, I definitely heard what you just said about other things that might take priority. In this case, it feels like this is, at least the staff recommendation, is pointing out in my reading that this is sort of an oversight or an error made by the hearing officer here. So something like this that's dealing with privacy, it seems very urgent. So if this isn't, if it's a, I don't want to use the word error. I don't know if that's fair or not, but it seems like the need to remand it was because of something the hearing officer either did or didn't do, as opposed to something that the applicant did incorrectly, or the petitioner did incorrectly. So I don't know if there's any way to. I can't really speak to whether it should be prioritized or not based upon everything else you have on the docket, but do you understand my concern there?
Sure, and we would prioritize it to the extent that we can, given people's schedules.
Okay, but roughly, if you had to guess, you'd say about 6 weeks before it came back.
Because Ms. Wodnicki has an upcoming vacation, so we can't send anybody out.
Okay.
When she's not here, and she would also need to testify. So even if we got her out, and then if we had a hearing, we have to provide 10 days notice of the hearing. So then there's that. Mm-hmm. So there's just a lot of time you have to build into these things.
And would it be appropriate, or is it ever practice to reach out to the landlord to see if there could be a different resolution here rather than going through the process that you just outlined?
Now, that is always the option of the landlord to go in and fix anything at any time.
But would our office do any sort of specific outreach in this case here before we initiated that 6-week process to try to resolve it without that?
No, because the parties have already availed themselves of the opportunity to have a mediation before they even went to hearing. And the landlord is well aware of what our compliance request would be to fix the blinds, regardless of if they open or not. The compliance is to fix the blinds. So,
and the landlords refuse to do that to this point?
I don't know.
Okay.
I don't believe we received a compliance request on that issue.
Okay. What are the other options that the board could take here if the board finds that 6 weeks is an unacceptable amount of time for something like this?
Your options other than remand? Well, you have the option of not taking the staff's recommendation and finding that there is evidence for what the hearing officer did. But if there is a question about whether or not there's a basis for the decrease, and that's a factual determination, you all are deciding whether or not there's evidence for that factual determination. And if you decide there's not, the only way to resolve that is to have it determined on remand. What you would be doing, though, you'd be affirming the findings. So the findings of fact and the decision for this particular issue are on page 12 of the decision. So you could affirm some of the other findings of fact and make sure that it's only remanded for one single issue, and make sure that what you're asking a finding for is very clear and limited. So that would potentially limit some of the burden on either the inspector or the hearing officer. She wouldn't have to go through the same decision. It would just be coming back to you with that one finding of fact.
So the motion that was made, is that consistent with what you just said, or would that need to be a substitute motion if we wanted to go in that direction?
You could probably modify the motion to say that you're affirming the other findings of fact in the decision, except with respect to that one fact about whether or not the blinds can be closed, either manually or otherwise. Can be closed for privacy. Yeah, that'd be great.
I have a question.
Okay, Commissioner Ambrose?
So am I correct in understanding there were two findings for decrease, one for the broken window, one for window blinds, two separate issues? Okay, then on that, I think I would make a substitute motion to adopt the findings and facts and conclusions of law in respect to the issue solely of the broken window, and to remand back to the hearings office, hearings department to find a determination of the rental decrease with further investigation solely on the issue of the window blinds for privacy. So that's my substitute motion.
Do we need a substitute motion or just the original motion maker?
Well, just so I understand, Commissioner Ambrose, you're suggesting that we not accept the hearing officer's findings of fact on the window blinds issue. You want that entire issue remanded?
Yeah, so that we don't adjudicate the whole thing from the beginning. And I hope that that's not what would happen. So that we are only looking at one issue.
Right, so that's what we were doing before. We were proposing to accept, but also we were proposing, or what I understand Commissioner Ivanoff's motion is to accept some of the findings of fact, even on the window blind issue, and the only fact that you're asking to be remanded about is whether or not the blinds can be closed for privacy. Because in the decision, there's a finding of fact, for example, that these blinds were installed around 2022. I assume that that is not something the board is disputing or wants to be relitigated. So if you're comfortable with affirming those findings of fact in the decision, except for the issue of whether or not the blinds can be closed, I would suggest.
Yeah, maybe I wasn't,
That's what you
we're in
wanted to
alignment,
do?
is that right? The
Okay.
substitute motion is in alignment.
And whether the amount
the
of
original.
decrease needs to be modified based on the finding of whether they can close or not.
Yes.
It's kind of like a two-part.
Yeah, okay. So I'd ask you to,
Procedurally, we can just, he can just amend that motion rather than do a substitute motion.
yes, so if you just want to repeat your motion, Commissioner Ivanoff.
Okay, so I would move to affirm the decision with the exception that we only remand for the limited purpose of determining whether the blinds can be lowered for privacy and to evaluate the amount of the decrease based on that fact-finding issue.
The queue just isn't cleared here, so is there a second?
Commissioner Ambrose was first.
Okay.
I was in the middle, and then Ivanoff was at the end.
Okay, before we move to any comments or questions, do we have a second on that amended motion?
Yes, I
Commissioner
second
Leslie.
the.
Okay.
Once again, I second the motion
Okay.
that Commissioner Ivanoff was. I'm sorry, Vice
That's
Chair
right.
Ivanoff was giving.
Thank you. So we have a motion by Vice Chair Ivanov, seconded by Commissioner Leslie. Are there any further questions or comments from commissioners? Commissioner Leslie?
So I also had the comment about the broken window. So it never does it state in here, if I'm not mistaken, that the window was fixed, and that the window is still it's still broken.
Right, and that's why there was a decrease, and that's why the tenant didn't appeal the decrease either.
Okay.
So
So-
that would, if and when that issue gets repaired, the landlord can request compliance from the hearings department to restore that decrease.
Okay. Would commissioners be friendly to the revisit of the amount of decrease for the window? Since we
It's
can't?
not an issue before us yet.
It's not they didn't appeal
Okay.
that part
All
of
right.
it, so.
All
yeah.
right. Okay, thank you.
Okay. If no further questions or comment, may we have a roll call vote, please?
Yes. Commissioner Ambrose,
Yes.
Commissioner Dudek,
Yes.
Commissioner Leslie,
Yes.
Vice Chair Ivanov,
Yes.
Chair Gonska.
Yes.
Motion carries.
All right. Moving on to agenda item 14, the board discussion items. This item is a discussion item that Commissioner Ambrose and myself requested to put on the agenda tonight regarding Senate Bill 79 related to transit-oriented development, which is currently pending in the state legislature. Our purpose in bringing this item up here tonight for discussion is that the passage of this bill, SB 79, may have implications for the city's rent-controlled housing stock, including potential pressures that could affect the retention of such units. So I prepared just a very brief overview that I can run through, but before I do that, do you want me to do that first, or do you have any comment you want to make first?
You go ahead and, if you
Okay.
want to summarize, and I can jump
Sounds
in so we
good.
don't repeat ourselves.
Sounds good. And this is just sort of my comments. It's a very brief overview, and it definitely is not attempting to summarize the entire bill because there's a lot in it. But my comments here, my summary I tried to pull out the parts that are in particular relevant to rent control and the potential impact on rent control. So SB 79 preempts local zoning rules to allow increased density and height limits for new housing on commercial, and importantly, and somewhat controversially, also residential properties near public transit stops. And there are specific definitions within the legislation to define what a transit stop is in regards to allowing extra additional density around those transit stops. So it's light rail, and it's also bus stops, but the bus stops are defined in a way that don't apply to Santa Monica because they require a separate right-of-way dedicated for those buses, so dedicated bus lanes, which we don't have here. So essentially it's impacting the three train light rail stops that are in Santa Monica, as well as a fourth that's just outside of Santa Monica, but the radius defined in the legislation would spill over into the city. The bill also does make exclusions specifically for rent-controlled units. So the first is a site containing more than 2 units where the development would require the demolition of housing that's subject to rent control that's been occupied by tenants within the past 5 years. Or also a site that was previously used for more than 2 units of housing that were demolished within the last 5 years, and any of the units that were subject to rent control. This bill, SB 79, the initial bill was first introduced at the beginning of this year, and it had been amended 10 times before it was ultimately passed by the state Senate earlier this year. Of note, it passed with 21 votes in the Senate, which was the minimum required for it to pass. And Senator Ben Allen, who represents us here in Santa Monica, did not vote for the bill. When the legislature comes back into session, I think next week, this month, certainly the bill will be taken up by the Assembly, and I think, as we're all familiar with, it must pass the Assembly, and if there are changes, also be passed again by the Senate by the end of this current legislative session, which is September 12th. So just to keep in mind, our next meeting is September 11th, we also, as I mentioned at the top, there's a lot of other details that are part of the bill, so I don't want anyone to think that this is a full summary of the bill, but I just wanted to pull out the parts that are particularly, in my opinion, relevant to us here tonight. I think at this point we can move to public speakers on the comment, on the item, I mean. So we do have one, Michael Soloff. If you'd like to step up to the podium, you'll have up to 3 minutes to address the board when you're ready to begin.
Thank you. I'm Michael Soloff, co-chair of Santa Monicans for Renters' Rights. SMER has long supported transit-oriented development on commercial boulevards and commercial zones and in the downtown. But SMER also has long opposed such development within the city's neighborhoods so as to avoid displacing existing renters and so as to preserve existing rent-controlled housing, which is the only housing in the city that's affordable to middle-income households. To accomplish this, SMER has supported local zoning rules that keep heights and densities low within neighborhoods, but permits considerably more height and density on the commercial boulevards and commercial zones and in the downtown. And this strategy has worked, as almost all of the robust multifamily housing construction in the city takes place outside of the neighborhoods. State Senate Bill 79 seeks to promote new housing development near high-quality transit, a goal SMER shares. But SB 79 does so by authorizing the building of dense and tall buildings near major transit stops, irrespective of any local zoning limits, such as those protecting our neighborhoods from redevelopment pressures. In our city, SB 79 would override our much lower zoning within the Pico and mid-city neighborhoods. When SB 79 came before City Council in May, SMER urged Council to oppose the bill unless it was amended to exclude rent-controlled and other existing housing sites. SMER was shocked and dismayed when Council voted to support SB 79 without insisting on such protective amendments. SMER then reached out to Senator Allen and Assemblyman Zuber and urged them to oppose SB 79 unless amended to protect existing renters and rent-controlled housing. In response to a single call to action email, more than 300 Santa Monica renters also immediately emailed the senator and assemblyman urging the same. Both said that they stood with us and Santa Monica renters. Senator Scott Wiener, SB 79's author, however, refused to make the protective amendments. As noted, SB 79 just squeaked out of the Senate, and both SMER and allied tenants' rights organizations from LA and SF continued lobbying in the Assembly. Thanks to Matt Haney, the Assembly Housing Committee Chair, significant tenant protections now have been added. Sites with more than 2 units of rent-controlled housing, or that had such housing in the last 5 years, are now excluded from SB 79. And the local right to adopt even more protections for rent-controlled housing, such as all rent-controlled housing, is now expressly granted. So that could come back before everyone. But SMER and allied organizations continue to press to extend it to 7-year look-back, not 5, and to cover exclude all rent-controlled units. SMER urges this body to stand with Santa Monica renters and to.
Thank you very much. I don't believe we have any other speakers on this item, so we can move to board discussion. So, Commissioner Ambrose.
Yeah, so I just wanted to make some comments also about, starting with Section 1800 of our rent control law, which states that in addition to giving tenants the opportunity to contest any rent increase, the article attempts to provide reasonable protection to tenants by controlling the removal of controlled rental units from the housing market. And in the spirit of our charter, any housing that, in my opinion, is displacing tenants is governed by the spirit of our charter and not wanting to, it's not removal of housing stock, but removal of tenants from their homes that are in rent-controlled units. And my other comment is that I feel that SB 79, and maybe other iterations and amendments it has, but did not consider the local needs and differences of each community within the city or within the state, and that the city of Santa Monica is fortunate and to be one that has rent control, and whereas others don't, but have differing needs. In my research, I found that there were 89 other cities that opposed SB 79, and only 2 that were supportive, one being Santa Monica with some limitations or reservations, and then the city of West Hollywood. And then I just had a question. I'm not sure if someone could explain the requirement of the housing within the last 5 years that's excluded, and also in conjunction with the Ellis Act being 5 years that you have to be off the rental market, and how those two would interplay time-wise.
I think, so that was your question for.
Yeah, well, I don't know if it's for staff or for us to discuss.
Yeah,
I mean, okay, well, I guess I'll further explain that. In my reading of it, let me see what. Okay, so section 65912.157H says it can't be used to demolish properties that have been subject to rent control in the past 5 years. And the Ellis Act is also congruent with the 5-year deadline. So I'm wondering if whether developers would have an incentive to evict under the Ellis Act, then wait 5 years and take advantage of both SB 79 and the Ellis Act. And so that's that question. And then also just to echo the sentiments of displacement with new construction, that these are people's homes, and as we've seen with San Vicente and the makeup of people in their homes, relocating is not an easy task. And I personally feel that this body should be only supportive of bills that are not further displacing our rent-controlled tenants in the city.
Yeah, I think in terms of your questions, I think that's part of from what I've heard and read from the coalition that's asking for amendments is that there's a complicated web of not only this proposed legislation, but also, as you mentioned, other law, that Ellis Act and other law that has a complicated web of requirements for affordable housing, percentages of affordable units, depending on density and total units. And I think that's some of the concern that some of the coalition has that's opposing it currently, is which laws, local versus state, whether SB 79 or other state laws, would take precedent. And within that web, sometimes it would allow for a greater density without requiring additional affordable units, which I think is what you're getting at with your question there. So I think in terms of for staff tonight, I obviously don't want to speak for staff, so feel free to weigh in if you have additional comment. But what I was going to suggest was that that we ask the staff to do an analysis of which units in Santa Monica could potentially be impacted by this legislation. And so certainly if we ask them to do that analysis, we could also ask them to include analysis of your question, of in particular the number of years that are required, and could that potentially, how would that interplay with the number of years that are required under the Ellis Act? So we could include that as part of what we would hope to learn from staff before our September meeting if we wanted to. Did you have any other comment or question?
I'm not sure. Was that like a motion
No,
to
not at this point.
Okay,
I'm
so
just
no motion
suggesting
yet,
that.
but a suggestion.
Well, I was just
that
suggesting
staff
that
could come back with questions. if we
the
direct
staff
them
might
to.
not be prepared to answer that question tonight. And
One thing I want to point out is we did check with our legislative lobbyist about the time frame for opposing, supporting, whatever the board wants to do or not do. And since the legislature has to be done with everything by September 12th, your next meeting would likely not be timely. If we can try to get as much information as you want, and have perhaps if you want to discuss it further, have a special meeting before the 2nd, which is the date that we were told would kind of be the drop dead date for presenting a position. So if there's specific information you'd like to have, we can do our best. Come back before the 2nd, and if that's what you decide to do.
do you think that's a sufficient amount of time to do that analysis of? Because really, I'm interested in like how many units, in particular, where those units are that could be impacted by the legislation.
Yeah.
So does that give you enough time by September 2nd to do that?
Yeah, Dan, can you maybe?
So good evening, commissioners. So I've already reached out to our GIS team in the Information Services Department, because they have the technologies where they can draw that radius around the transit stops and identify addresses that would be affected. And then we can cross-reference that with our database, and we can look at the number of units on those properties, and we can give you that report. It's going to be up to ISD how quickly they could possibly do that, but I understand they have the technologies to do that, and it's possible.
Okay. Yeah, I think, and also, I guess I'm adding complication here in a short period of time, but it would be helpul to understand how, like, with the current way the legislation is written, where it's 2 or more units versus if that number were changed, you know, if it like the public speaker tonight suggested that the coalition supporting excluding all rent-controlled units from within the legislation. So, like, an analysis of currently with 2 or more than 2, I think is how it's written, versus if all were excluded.
That's right, more, 2, or yeah. So we can identify the total universe and then show you how many are more than 2 units and how many are less than 2 units.
Okay. Thank you. Commissioner Leslie?
So my questions are what I want to be taken into consideration, the effects on the Pico neighborhood, which usually gets the low-income affordable housing. That's where everybody goes to build. Also, the impact on gentrification. How does this bill affect gentrification? Will this amp up gentrification throughout the city of Santa Monica? Those are the things I would like to be looked at.
Yeah, I share those concerns, and I think that's, you know, from just looking at a map of, without getting super technical like we would get from the analysis that we just heard about, just looking at a map of where those, and we know where those train stops are, right? Mm-hmm. That's generally, it's not just the Pico neighborhood, but it's a lot of the Pico neighborhood that would be impacted. So I think that's where some of the concern about allowing for additional density without requiring additional affordable units is a major concern.
Well, we don't
because
have
of the neighborhood in particular that's impacted.
Yeah, we don't have enough affordable units in the ones that are actually equitable in their size and stature in the first place. We're talking about the college. We're talking about all those areas in the Pico neighborhood, which is packed with affordable housing units. Community Corp is very advanced in that area. So what needs to be looked at is other parts of the city. I will go along with the rest of my constituents that we have been advocating for years for affordable housing to be built elsewhere within the city, other than SB 79 does not seem to be advancing that motto.
Vice Chair Ivanov?
To me here, I'm mainly concerned with, you know, what is the most effective step we can take, actual concrete action, given the timing restriction we face here. I think we've already determined that a study going through our normal procedure, normal schedule by our next meeting in September is not sufficient. We obviously don't have a resolution before us today either to vote in against or support. However, that being said, if there is an option to fast track and it is feasible to have a special meeting by September 2nd, I don't know if we have to bring a motion to do a special meeting or what the process for that is, but if we're assured that this can be done timely, I would be inclined to vote in support of a special meeting.
So you don't have to make a motion for a special meeting. We can just schedule one and send out the appropriate notices. I think what staff will need, and I think you heard from Dan, we can't guarantee that ISD is going to be able to supply the information that you're asking for within that timeline. So it's a risk that you'll be trying to decide this issue without all of the information that you need. And I don't know what, this is August 14th. There's Labor Day is, August 29th or something. So you're at less than 2 weeks to schedule.
We might be able to do it on the, I have to check with Gilbert. We might have the chambers on the 28th. We can shoot for that. I can't guarantee it, but we could shoot for that.
Well, what happens you said it's a risk, but in the event that we schedule this meeting and we don't have the data by then?
Well, in theory, we can still take a vote without the data. It just, we would have less information to make our determination.
is that enough time? Is a 2-week time frame enough time to draft the resolutions?
If you give me the direction that you're leaning in, I can have something drafted for you. What I'm hearing are concerns about affordable housing, concerns about displacement for rent-controlled units. It sounds like you would prefer, and correct me if I'm wrong, that that there not be this exception for 2 units or less, that all of the rent-controlled units in the city be protected. But I would need that direction from you as to how you're going. If you're leaning toward oppose unless amended, or if you're saying support, but we are asking, what you're asking for.
And just to clarify, it's not to decide that tonight, but just to give you direction on presenting a proposed resolution.
Correct. And you can give me a couple of options if you want to do that.
Okay. And one other question for Dan. When it comes to the data data analysis, is there any other, if the other city department can't get back to you in time, is there anything we can do internally that it wouldn't maybe be as accurate, but could still give us more information than we have today to make a decision based upon looking at a map yourself without being super precise with their tools?
Right. I think that's what it would come down to, is us just kind of, estimating, the half-mile radius or quarter-mile radius. I'm sure you probably just want the half-mile radius. And, we can look at, parcel numbers and maybe be able to identify which are in that range. I mean, we don't have an easy way of doing that. It would be, quite manual to kind of go through all of that and see what we could come up with. That's the best I could offer.
Okay, and so it sounds like perhaps maybe you certainly wouldn't be able to give us an exact number, but you might be able to give us an estimate, say it's hundreds, not thousands, or something along those lines, as opposed to a precise number.
Yeah, I think, we can look at street addresses, and block numbers and find, which controlled properties are within those areas and give you something.
Okay, that's helpful. Thank you. Commissioner Dudek.
Yes, I wondered if we could ask a question of the speaker at this point, or are we're discussion? Okay. All right.
Well, you can still just.
Okay. Well,
you can speak. You can ask your question to us and.
Yeah. Well, yeah. I mean, this issue has been around for a while, and there's been a lot of opposition from all quarters on it, about it, but it sounds like there's no chance of. It's not about opposing 79 now, really. It's about focusing in on this issue, about rent-controlled units and greater protection for all rent control units. Am I right on that? Is that what we're talking about?
Well, at least for me, I think personally, I would not support it as is. That's just in our discussion, my personal opinion. And the reasons being, it's particular language in relation to rent-controlled units. And then also, I'd like to just, bring forth to the discussion just the general nature of SB 79, which in general takes away local authority in making these decisions. So, that would be on the not support side for the general reasons, although there are obviously good things about the bill, in that its intention is to increase housing generally, but just for our limited knowledge and jurisdiction, to either not support because of language, or to support only with amended language regarding rent-controlled units, and then we would need some sort of report back just on the particulars of that.
Mm-hmm. But I do have a question. Is it too late to totally oppose 79? That's my question.
No, not at all. You can also just take an opposed position.
oppose unless the amendments are strengthened. We could oppose the bill in its entirety.
Sure.
Unless we strengthen to include all rent control units instead of the 2 or more language.
Right.
That's my question.
And if you'd like, I can bring back both of those options to you and any additional option you'd like.
And then so if we have the special meeting, that would be when we would vote to either oppose or support in whichever way. And then we would have our staff write a letter that goes out formally from the board in agreement.
So I would draft a resolution based on the recommendations, and then you could vote to support one of those, or amend. I could change it on the spot, and then that's what would be sent.
Any other comments or questions? Okay, so will we make a motion to, or just give that direction to you conversationally? Okay, so yeah, I think the direction would be to prepare and present to us a resolution opposing SB 79 unless there's amendments that exclude all rent-controlled units and also lengthen the amount of time beyond 5 years.
And also, if I could get the, more knowledge or understanding about the Ellis Act timeline and then the 5-year timeline and how that may or may not incentivize certain construction or Ellis acting. I looked into Barrington Plaza and the limited scope of the decision, because I thought that would be something relevant to our decision to look at. But if that could also be included in the analysis, whether, as an example, and when you come back with the proposed resolutions, if you could also provide some understanding on those two things.
And does the board also want an option to simply oppose the bill as well?
I would, just as an option.
Okay.
Yeah.
Any other direction? That sounds good to me. Okay. All right. Great. Thank you. So that concludes our agenda for tonight. Can I have a motion to adjourn to our next regular meeting of the Santa Monica Rent Control Board on September 11th, pending the proposed announcement of a special meeting before then?
I'll make the motion to adjourn.
Do you have a second?
I second that motion.
All in favor?
Aye.
Meeting is adjourned.